And in your line of work, pain and suffering is included in the settlement amounts or in verdicts?
In wage claims, no. But in discrimination, harassment, retaliation claims, absolutely. I mean, that's as big of a component, I think, as their lost wages, because they're entitled to recover what they lost in the past and what we think they're going to lose in the future. So if you're out of work, or you're going to be out of work, or then you get a new job, but you're making less, that's part of it. But then the other part is the struggles. And, I talk to my clients about, when they wake up in the middle of the night in a cold sweat because they don't have an income and they don't know how they're going to pay their bills. And I think, everybody understands that. Everybody's had that struggle. And so that's a big component of what we try to fight for.
Hey there, hot messes. Welcome to Success of a Hot Mess, where we celebrate the art of juggling life's chaos and coming out on top. I'm Stacey Isaacs, your host and resident rock star lawyer, dance mom, and survivor. We're going to dive into candid conversations about conquering challenges, embracing our unique selves, and finding success in the beautiful mess of it all.
Good morning. We have the pleasure today of speaking with Brian Pollack, owner of Fair Law Firm. Could you tell us a bit about what your firm does?
Morning, Stacey. Sure. Our firm is in Miami, to Coral Gables to be specific, and we represent mostly employees or people who should be employees in cases involving wages, retaliation, discrimination, and whistleblower claims. And, we're fortunate to be able to work with your firm in cases on a pretty consistent basis, so thanks for having me.
My pleasure. There is definitely sometimes a marriage, so to speak, when an injured worker, who I would represent, obviously gets hurt on a job, they hire us, and their number one question is always, will I get fired for doing this? And generally what I tell them, and you can tell me if this is good advice, is Florida, you can pretty much be terminated for anything unless it's an illegal reason. But if they suddenly let you go because you've hired an attorney for your injury, we are going to refer you to Fair Law Firm because there could potentially be a wrongful termination. Would that be?
That's totally accurate. I mean, Florida law, one of the statutes that you guys deal with a fair bit under Chapter 400, there's the 205 claim, 440, the 205 claim, which says that you can't retaliate against an injured worker because they attempted to bring a valid workers' compensation claim. So although Florida is an at-will state, you can be terminated for any legitimate business reason. You can't retaliate, so you can't reduce somebody's hours, take them off the schedule, or fire them because they hired a lawyer to represent them in a workers' comp claim, or because they tried to bring a workers' comp claim. And, we see those kinds of claims all the time. And a lot of it depends on how long somebody's worked there, how long they're out of work, and whether there's a punitive aspect that we can bring in to make the claim more valuable, to punish an employer so they don't do it again.
Okay, great. And how does your firm work in a claim like that? Is it contingency?
We're on a contingent basis, so we become, for the most part, partners with our clients. The way I explain it is, we're in a partnership in these cases because of the contingency, but the nature of our practice, we're usually at a 40% contingency, so we refer to ourselves as minority partners, which means we don't make decisions about whether to settle or when or how much to settle. We'll make recommendations, but it's always our clients who make those decisions about when and if and how much to settle with our guidance.
I did have an issue on a workers' comp case. I want to get your employment take on it. Back when COVID was very prevalent a few years ago, I was representing a nurse who was simply refusing to be vaccinated, and she was let go by the hospital. Was this a hot topic?
It was a really hot topic, and we consulted with a bunch of clients on those issues, and the law really didn't protect people who refused to be vaccinated unless they had a religious or medical reason to do so, and those were hard to come by. Although those claims existed, we didn't end up bringing a lot of them just because of the law was so unsettled. And then the other part was, it's kind of like a car accident where you get rear-ended, but there's a scratch on your bumper. is a lawyer going to take that case if there's a scratch on your bumper? And sometimes what we find is, yeah, there's a serious violation of the law. You know, that you absolutely had a sincerely held religious belief. It prevented you from getting a vaccine, but you're out of work for 2 weeks. Is it really worth bringing a lawsuit over being out 2 weeks? Not just for us, but, you know, for a client's perspective, do you want to invest the time in responding to written request for information, sitting through a deposition, being interrogated about your life when you're talking about 2 weeks being out of work? And it's really raw, and people get upset about it at first, but that rawness, I think, fades over time. And that's why we like to bring that up to clients so they have a really good idea of what they're getting into.
Say somebody who was employed for 20 years and, you know, gets let go for refusal to have the vaccine. That was kind of the situation we were presented with. And while the person was on work restrictions from their work injury, the workers' comp carrier denied it based on a voluntary limitation of income, which was refusal to have the vaccine.
Yeah, I mean, if it's a personal refusal, you know, I think that's looked at differently than somebody who has a sincerely held religious belief or medical reason as to why they couldn't have it. Because I think the way that the courts have looked at these so far, if you just simply refuse to have it, that's on you. But if it's you're refusing to get you refuse the vaccine because of some medical or sincerely held religious belief, then that would be protected, and you couldn't be fired because of your refusal when it's tied to one of those protected issues.
And how would you prove a sincerely held religious belief?
You know, sometimes we've looked and we've had clients that came in that had letters from their pastors.
Okay.
You know, so-and-so was attending this church and they'd done it for years, and, you know, the pastor goes in and explains it. And I think that's really the only way you can do it, because how do you prove you go to church every Sunday? Or how do you prove you go to a synagogue or wherever you go and worship? How do you go and prove that? You know, you need from some religious leader. I think that's the best way to do it. And then they look at other aspects of your life. They probably troll your social media. I mean, that's defense lawyers, and I know you've encountered that. Defense lawyers are good at, and insurance companies, trolling people's social media to see if what they're saying is how they're living. So
exactly.
I think those are things that we see.
So another topic that comes up when we get an injured worker calling, we sign them up, and then a couple weeks later they call, they say, my employer, you know, my boss is being so mean to me. I think it's because I had this accident. I think it's because I had I hired a lawyer. And from my perspective, I would feel like it's premature. You know, they haven't been terminated, but how much, when does it rise to the level of harassment where they should call the fair law firm?
You know, that's a tricky one, because the courts don't want to get involved, and they don't want to be judge doesn't want to be an HR person. So the way that it's really looked at is if it really affects the terms and conditions of your employment, and how I look at that is, you know, is it so miserable that your only option is to quit, where they're really forcing you out, where, you know, before you may have been doing one kind of job in the office, and, you know, let's say you're at the computer, and then after your accident, they decide, you know what, we're not going to have you working at the computer because of your work limitations, but now we're going to put you in a warehouse that's unair conditioned, you know, where cars or forklifts are operating. And so now you're inhaling all this carbon monoxide in an unair-conditioned warehouse in Miami, but you could have been doing your job at the air-conditioned desk inside of the cubicle. That's when it gets really bad. But otherwise, it's kind of a tough judgment call. But I think really once it gets intolerable and you tell your friends and they go, that's ridiculous, that's really the point where it makes sense to bring us in, because not only does the condition have to be bad, but you've got to suffer damages. And so, you know, it's tough when you're going to go and put yourself at the end of the day when you're in front of a jury. And the jury members, most of them work or have worked. And they've all had tough days at work, and they've all had tough jobs. And you're going to say that my job was worse than yours, and it was so much worse that I should be awarded damages. So that's kind of the perspective that we have to put it in order for it to make sense for us to bring that kind of claim. But we evaluate those cases all the time, and we're honest with people. And I think that's where our firms align a lot, is to be honest up front so we can set expectations of, you're going to have a claim and it's going to be a good claim, or you're going to have a claim but it's not going to be a really good one, or we just don't think it's worth pursuing.
And we appreciate that honesty. Have there been any super interesting circumstances surrounding any employment cases that you've handled recently? And can you tell us maybe the largest judgments?
We had a case, as far as our biggest case, that was last year. We had a case that was against a company. It's a company that operates out of multiple states, and it was for a bunch of Hispanic workers. We ended up meeting with them during COVID, so I remember vividly standing outside because nobody wanted to be in an office, and we went through and did all the initial paperwork outside, and we ended up resolving the case at a mediation, and it was a fairly substantial, let's say 7-figure case, and it turned on an HR person really talking about what she experienced and how she felt like she was discriminated against because she was Hispanic. And that was a huge turning point once she came in and gave this declaration. It really broke the case open, but that's because we were vigilant in talking with everybody that we could talk about and have somebody who was willing to say, you know what, I probably should have done something myself, and this is my opportunity to do it even though I didn't bring my claim in time. I'm going to help these guys. And, that was a lot of work, a lot of paperwork, but that was really rewarding because it was, we had 12 or 13 people, and they were packed into my conference room, and it was really rewarding when everybody came in to do that. And so that was a big claim. Another claim that we had was a workers' compensation retaliation case where our client was complaining that there was some kind of odor or something in his car, and he kept complaining about it, and they told him it was nothing. And it
was this a company car?
It was a company car. He had inhalation damage to his lungs, and they kept telling him, it's okay, stay in the car. He said, I can't do this. And he rolled his windows down. I mean, we feel what it's like in Miami at 85 degrees. It feels like you're at 100 degrees at night, and he's sitting there in a car with no air conditioning with the windows down. He goes and asks for medical treatment. They tell him no, so he goes and gets it on his own. And ultimately, he calls and says, when can I come back to work? When can I come back to work? And they ghost him. And so not only were we able to settle his claim, but we convinced a judge that he was entitled to recover punitive damages. And so once that happened, that case settled. And so that was from digging in. We went and we got the service notes from the Nissan dealership where the car was serviced to go in and start proving a lot of these things, to get phone records, to get call logs, to prove that they never called him. And it was just incredible. And the judge immediately, saw what was going on, and after our hearing said, yeah, we're going to grant the punitive damages right up the order, and the case settled shortly thereafter for a lot more money than he was making. So that's just a couple examples of settlements. But, we take cases to trial. We just had one a couple weeks ago, which was a wage claim for 4 people, and they ended up getting a judgment from our 7 jurors for $177,000 in bonuses and commissions that the company didn't want to pay him. And
so for our listeners, can you explain what is a wage claim? What does that entail?
Sure. Wage claims are people who are owed money as employees, and sometimes you're paid properly as an employee. A lot of times we see it where you're really an employee, but you're being paid as an independent contractor. And that's as a way to so that the company can save money, because the company is not paying workers' compensation insurance. They're not paying income taxes, your Social Security, your Medicare, your contributions. And if you're working overtime, they're not paying you for that. So whether you're misclassified or you're properly classified as an employee, it's when you're owed wages, and that can be commissions or bonuses or your salary. You can be owed minimum wages or overtime wages. And when you're owed minimum or overtime wages, not only can you recover what you're owed, not only can you recover your attorney's fees, but you can also recover what are called liquidated damages, or twice what you're owed. So if you're owed $1,000 and your employer doesn't pay you properly, that can be a really expensive lesson for the employer, because they're going to owe you the $1,000. Then they have to pay you a penalty or liquidated damages. They end up paying you $2,000. They're paying their lawyer, and then they're going to pay your lawyer. And so those wage claims get really expensive. Sometimes it's a technical mistake that an employer did. Other times we find it's calculated. They knew that they had their hand in the cookie jar. that our clients are working really hard and that they don't feel like they're making enough money, so they're going to take some of yours. And those are the clients we fight for. And, we take those cases to trial. And it amazes me because a lot of times our clients are in trial and they're saying, I'm going to get my $16,000. And then afterwards, the employers paid their lawyers a ton of money. They've paid our clients double what they're owed. And then they pay us. But it still doesn't bring back all the struggles that our clients have gone through. So that's really what we try to do, is be attuned to those struggles.
And in your line of work, pain and suffering is included in the settlement amounts or in verdicts?
In wage claims, no. But in discrimination, harassment, retaliation claims, absolutely. I mean, that's as big of a component, I think, as their lost wages, because they're entitled to recover what they lost in the past and what we think they're going to lose in the future. So if you're out of work, or you're going to be out of work, or then you get a new job but you're making less, that's part of it. But then the other part is the struggles. And I talk to my clients about when they wake up in the middle of the night in a cold sweat because they don't have an income and they don't know how they're going to pay their bills. And I think everybody understands that. Everybody's had that struggle. And so that's a big component of what we try to fight for.
So I don't know if you're aware of this, but in workers' compensation, it is not includable, which is just very hard for clients to grasp, because they are injured. They don't know how to pay their bills. It affects the entire family, and pain and suffering is simply not evaluated when it comes to settlement or if you go to trial. So that is good to know that on the employment end it is, or it can be.
It can be. I mean, and it's tough to explain to a client, and I'm sure you've had this problem. It's, I know that your average weekly wage payment is going to come in, but we're waiting for it, and then the client's like, what do I do in the meantime? And the credit card bills that mount up and the other problems that they have. And, so in the wage cases, it's like the workers' comp cases, it's difficult to explain to a client, I can't get you anything for that. The statutory scheme is done. Talk to your lawmakers, but it's nothing that we can help you with. And It's really tough to have those discussions.
It is.
And it's frustrating for our clients who live those struggles, and we just can't help them because that's what we like to do.
I know one of my favorite lines, if I'm speaking to an adjuster and I know that they've been late in sending out a client's check, I say, I don't know how you feel if your paycheck just doesn't hit the account for a couple weeks. I mean, people have to live, they have to pay bills. And unfortunately, a lot of them have to take like settlement loans just to get by, to pay bills.
Yeah, and I know those are tough on clients because those don't come cheap. I mean, it's not easy for the lawyers to, the law firms to do it because there's a lot of paperwork, and we're happy to do it for our clients, but it's tough to put a client into one of those.
No, I
discourage it.
I discourage it. I'll only do it if, their lights are being turned off or something like that, or they can't buy food.
I mean, but it's ultimately, it's ultimately their call, but I mean, we're trying to look out for the best interests of our clients, and it's tough to tell somebody, go into a loan and they're going to charge you these fees, and at the end of the day, we can't promise you how much you're going to get.
Yeah.
In your settlement or your judgment or whatever you're going to get, and then have somebody else take part of that, it becomes tough.
So how about this? Let's say a potential client calls your firm and says, I am feeling discriminated against and harassed about being overweight. Would that rise? I don't know if that's a protected class these days.
Yeah, I don't know either. I mean, I've kind of looked into that. There was somebody who contacted me who was working at a Hooters and who was being harassed about that. But my recommendation is if you feel like you're being harassed or discriminated against at work, the best thing that you can do is, number one, start taking notes. Put it in your phone. Write an email to yourself. Start a Word document, whatever it is, and start putting in dates and names and people who are around you and create a record. Because number one, it'll help you remember things. And number two, it becomes really powerful later when somebody says, oh, you're just making this up. And you say, no, actually, I didn't make it up. I sent myself an email, and here's a copy of the email that I sent from 6 months ago where I have all that information in there. And that becomes really powerful. The next thing that you're going to do is if you're going to complain, and you're going to complain to HR, and you're going to walk in there and have that conversation, which is a tough conversation, after you walk out, make sure that you send an email thanking the HR person, the HR professional, for meeting with you and for discussing your concerns about and then explain in the email what you talked about. Because a lot of times we find as HR, although they're trying to help you, they're not documenting as much as we'd all like. And so it's tough to say, yeah, I went and complained to HR. Well, HR doesn't have a record of it. And your response to that is, well, it's a good thing I do because I know I sent an email.
Yeah, that's really good advice.
And so, if you're experiencing problems at work, document them for yourself. And if you're going to go to HR, make sure you send an email or a Slack or something. And try, if you can, get a copy, great. But that way, at least that you did it, and make a note somewhere in your personal notes, hey, I sent an email at this time to this person. Because that way we can go in and request that document later. And if it doesn't exist, there's really big problems for the company.
Well, I really appreciate you coming in and shedding light on some of the employment issues, and we are happy to continue to send our clients who may need your assistance over to you. How can they reach you?
So at Fair Law Firm, you can reach us on the web at www.fairlawadtorney.com. You can call us 305-230-4884 is our phone number at the office. You can find us on social media at Fair Law Firm, whether on TikTok or Instagram, and we're happy to help.
Thank you, Brian Pollack, for coming in today. Nice to meet you.
Stacey, good seeing you again, and thank you so much for having me.
My pleasure.
Thanks for tuning in to another episode of Success of a Hot Mess. If you loved what you heard today, be sure to subscribe so you never miss a beat. And hey, sharing is caring. Share this podcast with your friends, family, and anyone who could use a dose of inspiration. Until next time, keep rocking those hot mess moments with style and grace. Cheers.